Jolly.
I know he hasn't been up. Is he responding at all to us?
No, Your Honor. He's just sitting there.
Okay. What are we going to do on this?
What I can tell the court, there was discussions between myself. Mr. Jolly also has cases pending in 15th District Court. Prosecutor there had spoken with jail staff about possibly getting a petition if the CMH worker in the jail. That does not appear to be something that can be done. What we then tried to do, or are in the process of trying to do, is work out a plea with Mr. Jolly. Mr. Chabalowski, who's the 15th District Court prosecutor, and Mr. Gaddy Mr. Gaddy just kind of going as standby counsel, attempted to go to the jail and speak with Mr. Jolly, I believe last week or the week before, but there was an issue with actually getting him to come up and speak with them, so they weren't able to facilitate any conversation about any sort of resolution.
Actually, Your Honor, Mr. Chabalowski and I, Mike Getty from the Public Defender's Office, Judge Perry he has not asked for standby counsel, but just in case he changes his mind while he's talking to the prosecutor, she asked if I would go, and I agreed. And we tried to go down. It was not a good time for the jail, so we're planning on doing it later this week, and we haven't had a chance. We're hoping to go tomorrow. Okay. So we did attempt to see him, but he didn't refuse us. But I mean, to be candid, he's refused everything else.
What do you wish for me to do?
I'm merely a reporter in this.
Yeah, no, I got you. Something out. I mean, this is sort of at a standstill. I mean,
I guess at this point we'll give them another chance to see if we can have some sort of conversation.
That's fine. So what I will do, I think, haven't we sent him for comp already?
We found competent, although the thing that struck me about that is that CFP relied on her earlier finding of competency, having not seen him for all.
Correct. So, all right, I'll adjourn the probable cause conference in this case to May 22nd, 25:09 a.m.
Thank you.
On continue. All right, thank you. All right, we're all set. Thank you, Lee.
Thank you.
Court calls the case People versus Byron Blair.
National Law for the People.
Honor, Alexis Plume, appearing with and on behalf of Mr. Blair, who is approaching. And Mr. Blair, could you state your full name?
Byron Blair. All right. I have before me a plea form. Indicates he would be pleading guilty to the charge of retail fraud, second degree, the 1-year offense. Upon a successful plea to that charge, count 1, retail fraud, and the first would be dismissed.
Yes, that is correct, Your Honor. I have gone over that offer with him, as well as an advice of rights, which should be in the file as well.
All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Byron Blair. All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of retail fraud in the second degree. Yes. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that? Yes, sir. All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that, sir? Okay. Okay. Understanding all of that, do you still wish to plead guilty? Yes. Are you sure that's what? Yeah. You scared me, like, who was Valvo? Oh, sorry. You are you sure? Like, who is Valvo?
Talked about the
Oh, she's the chief judge of the 15th District Court
in downtown Ann Arbor. So remember, Judge Simpson is not going to sentence you.
Oh, I got you. Okay, what you got me for? What are you telling me?
No, I understand what you were saying. The way you said it was like I was just imagining the executioner or something. Oh, I was scared for a minute. Like, who is Valvo?
Oh, so you thought Judge Valvo was an executioner?
Yeah, like you know, it's not gonna be me.
No, I'll call her today and let her know.
No.
I mean, I just to share that information.
No, sir. I'm sorry. Okay, I'm sorry.
Wow, and of all the judges. Okay, you're clear now. I'm just taking your plea. You would have a right to have me sentence you, but I need you to understand that this case is set not to be sentenced, that I would not do the sentencing.
Okay, I got you.
You got it?
I got
you. You okay with that?
Yes, I'm cool.
Okay, so understanding all of that now. Do you still wish to plead guilty to
Yes,
the
sir.
charge? You do?
Yes,
All right,
yes,
and
sir.
to the charge of retail fraud second, how do you plead?
Guilty, sir.
All right, now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, yes.
All right, you signed an advice of rights form, is that correct?
Yes, I did.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium there. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, yes.
You understand you're giving up your right to appeal of right.
Yes, I did.
Are you on probation or parole?
I just got on probation on the 11th in Detroit. Yeah.
So you're off. You're not under the jurisdiction of any court at this time.
I'm on probation. No.
He's on
No,
probation
I
out
just
of
took
Wayne
probation. I'm
County.
trying to get all of my.
I don't know what that meant. Counsel?
He was not on probation or parole at the time of the
No.
offense. He has now recently been sentenced to
Thank you.
probation.
Yeah, for old case, 2020 or something.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead to this charge?
Nope.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, I am.
of your own free will. And because you believe that you're guilty of this offense?
Yes, I do.
June 1st, 2024, at the location of 303 South State Street, City of Ann Arbor, Washtenaw County, State of Michigan. Tell this court what you did on that date involving the Emden store that makes you believe that you're guilty of this.
I exited with some items, but they got returned back, some Jordan shirts, a couple hats or something like that.
Okay, so you went into the store.
Yeah, I exited. Yeah, I didn't pay for it.
Okay, I got it. So you went into the store, you took property that
Yeah,
the store had for sale.
yes,
They were open to the public,
yes, yes.
and you tried to walk out of the store
Yes, I
without
did.
paying for that.
Yes, I did.
Is that correct?
So,
All right, to do that.
no, I didn't have no money.
All right. Was the value, is this on value or prior?
Value.
All right. So was the value total of the property that you tried to take out of the store, was that in excess of $200?
Yes, it was.
All right, counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Defense is also satisfied.
Defendant's plea to count 2. Count 1 is dismissed. The pre-sentence investigation and report is ordered through 15th District Court probation. Sentencing will be
It might be.
May 20th, 2025, 9 a.m. before Judge Valvo.
Okay.
Judge Valvo. Not execution.
I
All right?
And Your Honor,
I'm going to call her, though.
may I briefly address bond?
Yeah, go ahead.
Okay. Your Honor, we're asking the court to consider a personal bond for Mr. Blair. The reason that bond is set high on this file is because there were a couple of failures to appear in the past. Mr. Blair has explained that those failures to appear were due both to him being in and out of the hospital. He does suffer with congestive heart failure. And that's one of the reasons he would like to be out of custody to continue his medical treatment, as well as going back and forth between this county and the Wayne County Jail. He has now resolved all of his cases in Wayne County. I don't see that he has any out-of-county holds. He was recently placed on probation in Wayne County, so he's a little worried about picking up violations and not getting the programming aspects of his probation completed because of being in custody here. If he was released, he would be going back to the Delanis Center to live for right now. He is participating in their Pathways program. He has a caseworker there, as well as a CMH caseworker that he's been seeing in the jail. He did provide me with their contact information. And he does have a phone, so we'll be able to reach him. He just wants the court to know that he did not mean to miss his court dates, and would like the court to consider allowing a personal bond. His other cases in this county are retail frauds. They all have very low bonds set right now, just so that he was getting credit while this case was holding him. I do believe his other cases in 15th, he would get a,
Please go on.
I'm sorry, I do believe his other cases in 15th would revert to personal bonds if he was given a personal bond.
Any response?
Your Honor, this is one of 5 pending cases holding the defendant right now. They're all retail fraud. Yeah, I'm concerned with, I understand he's saying he was sick, but he did have, I think, at least 3 bench warrants in this case. So I'm going to request that bond continue at least until the time of the PSIR.
I tried, but I was in the hospital. And then one time y'all pulled it back because y'all had me mistaken. Oh, can I talk?
You were in the hospital, you were going back and forth between Wayne County and here.
I called your office up here, and I was known that it was a mistake because y'all had me down as being in custody doing
Y'all, that's me.
Not y'all, okay.
Go ahead. No, I'm listening.
The Washtenaw County court system, right?
Oh, that big y'all.
Okay, yeah. The big
Okay,
y'all.
yeah. Okay, go ahead.
Okay. It was a mix. Okay. One incident. I left here. I wasn't released from custody because I was picked up by Wayne County. I was held there, didn't Zoom. So when I get out of Wayne County on tether, I had a warrant for you instantly there.
Acting really, why are you nodding like all this is? No, go ahead.
Like this is crazy. I just been ping ponging back and forth between Wayne County and Washington. So while I was in Wayne County, they never zoomed me to come here. So when they kicked me out on tether, when I paid bond, I get out on tether, right? They say you have a warrant in Washtenaw County. For what? For not going to court. I said, okay. I come out here to Washtenaw County. I ended up in custody trying to figure out how to turn myself in. I come back up in here, y'all set me another court date. Now guess what happened?
That's it. Big y'all.
The Washtenaw County court system.
Okay, go ahead.
Okay, now this is what happens the next time. I'm on tether. They cut my tether off because I was in here so long waiting to see you that my tether went dead. Now I got to go back to the new Wayne County jail, which is like backed up 2 to 3 weeks just to get out on tether. So by the time I get back out on tether, they had me another paper again to say you would now have another warrant in Washtenaw County for missing court. I'm ping-ponging back and forth. When I just got my tether off on the 11th, they called y'all Washtenaw County.
Y'all, all of us.
They called the courts up.
Okay.
They let y'all know.
I'm just trying to
because you gotta have a lien. You gotta have a lien when you get sentenced to probation time. So I went in prepared to come in, right? And this and that. They told me, advisor release, take care of it when you get up here. So I got up here. I got with my caseworker. This, that. I was supposed to be going to this transitional housing stuff set up. This and that. I made sure I had my housing stuff set up here first. And then now I'm trying to see what you.
If I give you a PR, will you stop?
Yes.
If you don't send me back to Detroit and ping pong me, yes. Whoever said that, yes. That's the first time I ever been able to talk.
No, I don't believe that for a minute. You are too good at talking. That could be your first time.
All right, sir.
Well, he's got other holds that are going to hold him in. But if you're asking me to reduce this bond, right now it's at 1,000 cash or surety.
No, they said that the bonds that they gave me, that it will convert into.
So he wants a personal bond on this case because that would make it a lot easier to get personal bonds on his other Washtenaw County.
Oh, I got it. I was just ready to rule and he started talking again.
I think he did a great job.
He did. He did a fantastic
Better than me.
job for the last hour.
Yes, Your Honor.
That's what.
Yes, there were other holds. I said yes.
And
4 other cases that have.
that's what you were saying.
Yeah.
Before we.
And I'll just put the court's information to you. I see a 2019 case, 2022 case, 2023 case, and a 2024 case.
Request to reduce his bond. They'll set his bond at $1,000 personal recognizance bond.
Thank you.
You're welcome.
Thank you.
Take care.
You too,
And
sir.
I've already sent a message to Judge Valvo. She's waiting for you. All right, take care. Bye-bye.
All right, y'all.
Call the case People versus Deshaun Clifton.
Your Honor. Assistant Public Defender Dr. Lee on behalf of Mr. Clifton. And Your Honor, today we're going to be requesting an adjournment. Mr. Clifton, can you state your name?
Deshaun Clifton.
Thank you.
And Your Honor, today we're going to be requesting an adjournment of the PCC in order to receive some outstanding media discovery of the dash cam and body camera. I have prepared a green sheet.
Okay, you have a green sheet?
I do.
Objection. Probable cause conference will be adjourned May 15th, 2025, 9 a.m. Bond continued.
Your Honor.
Thank you. Case People versus Zachary Bruno.
Richard McDuffie for the people. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Bruno. Mr. Bruno, will you state your name for the record?
Zachary Bruno.
Thank you.
Your Honor, we're asking that this matter be set for a preliminary exam.
All discovery is complete.
To our knowledge, yes.
People have their witnesses available to 6. Pardon?
We will try it.
Examination in person, May 6, 2025 at 9 a.m. before Judge Perry. Bond will continue.
Thank you.
Oh, that I passed it? I thought he was on his way. Let's call the case. People versus Antonio Cornelius.
And good morning, again, Laura Yagi, Assistant Public Defender with and on behalf of Mr. Cornelius, who's approaching. Can you say your name for the court?
Antonio Cornelius.
And Your Honor, we would respectfully ask for this to be set for exam.
You seem to be doing better than your last case. Okay.
To
Discovery is complete.
our knowledge, Your Honor.
All right. People have their witnesses available on the 6th. Preliminary examination in person, May 6, 2025. 9 a.m. Sorry. 12 p.m. 12 noon before me.
Thank you, Your Honor.
Thank you. Courthouse case, People versus Gregory Davis.
Richard McDuffie for the people.
And that is me again, Laura Yagi, Assistant Public Defender with and on behalf of Mr. Davis, who is approaching. Mr. Davis, could you say your name for the court?
Gregory Davis. Thank you.
Your Honor, this has been postponed a couple times. And we were trying to see if we could consolidate it with the case that we were told is upcoming. That case has not been charged or authorized. So we are asking for an exam date at this time. In terms of discovery, I did request the 911 call back in March. We don't have it, but I don't want to keep waiting. Mr. Davis is held in jail on this, and so I can't keep adjourning it just for that.
People have their witnesses available to 6.
We will try our best, and Ms. Yagi, I thought we sent that 911 call to you a few weeks ago, so I will check on that again.
Thank you.
Preliminary examination, May 6, 2025. 9 a.m. before Judge Perry.
May I briefly just address bond?
Briefly.
Okay, this is one of two cases that are holding him, or he has 1 or 2 cases out of 14B. One is just traffic, one is DV. He has done over 50 some days on the DV 14B case. He was set for final settlement tomorrow, but then he was removed from the docket because they didn't know he was in jail. Somehow he had just been sitting with that outstanding warrant without being arraigned on it. He is now set to go to 14B on Monday. And obviously, I don't know what they're going to do, but I would ask if the court would consider lowering his bond. It's a 5,000 cash surety right now. I would ask for a 10% provision to be on there, because just in case they do give him a personal bond in 14B, which I'm very optimistic that they will, because he's done so much time on that case as it is. He has a job at Cracker Barrel waiting for him. And just to be candid, Your Honor, I've been representing him. This is, I think, our third PCC together. I've met with him several times. He's met with CMH in the interim. Personally, I've noticed a difference. When I first met with him, he was very loud. He was agitated. We had a really great conversation, and he actually thanked me for pointing out to him that he was so loud. He's met with CMH. He's been so genuinely reflective since. And I really mean that. I don't say that, as Your Honor knows, I don't say that about all clients. So I think he's really done a lot of reflection. And so I would ask if the court would consider a 10% provision.
I can't speak to what 14B is going to do. Obviously, Mr. Davis's case, the issue that we have with Mr. Davis, I think, is primarily the fact that he had a case pending for exam. That case did end up being dismissed at this point because we had a witness that was not available. An officer that was going to be gone for quite some time. When one of Mr. Davis's cases was pending, we had a new incident where he showed up to that victim, who's his mother's house, and was trying to get in. Essentially, we have NDOB on that case. We have some bond concerns, obviously, there. The domestic violence case, I don't believe it's related to some of these other incidents. The new warrant, I've heard, we do not have a response back on that further yet, but that is a completely unrelated UDAA allegation as well. Mr. Davis, should he be released? I'll leave that to the court's discretion. I do know that Mr. Davis has, I can appreciate that Mr. Davis has been improving. I think that maybe because he's had a chance to essentially detox. I know that he was under the influence of apparently narcotics, I think, at the time of this incident. And Mr. Davis has a warrant out of the 35th District Court for controlled substance possession. I don't know if he is aware that that is out there. He was arraigned on that on November 10th of 2024. And that bench warrant, was issued a few weeks after that, so November of 2024. So if he were to be released, I don't know if there's a testing order on his file. We'll be requesting that, obviously, in his history. And hopefully he'll be able to get that one as well.
Your Honor, may I respond very briefly? I just have to clarify something.
Okay.
Ms. McDuffie stated he went to the victim's address. He was on house arrest there. He was supposed to be there. So this is not a case where he returned to the victim's address against the court order. He was literally on house arrest there at the address with his mom, who they're saying is the victim. But he was supposed to be there. So I just have to clarify that for the record.
Are we done?
Yes, Your Honor.
Okay, I'm going to grant your request.
Thank you.
This bond will be set at 5,000. I'll give a 10% privilege on that. Thank you.
Thank you.
Are there any no contact orders on this matter? I'm not sure what Ms. Jackie was referring to. We got a contact order with it at the time. So
that is not true. He had a consensual contact order. We have to be clear for the record. It is not true that he had a no contact order. He was on house arrest there at his mother's address. He was allowed to have contact with her. He was supposed to. Is
that Ms. Freeman?
It is Martha Freeman, yes.
Okay, what I have is, I have a no contact with her at this time.
With this case, not with the other case.
Okay.
Thank you.
thank you for your concern.
Thank you. Okay, so
Thanks. Court calls the case, People versus London Dottery. Oh, boy.
Portia Feaster, First Assistant Public Defender, on behalf of Mr. London Dottery, who's approaching the podium.
Did you apologize to Ms. Constantine?
I did, Judge.
Did
She
you?
graciously forgave.
Did she accept your apology?
She said she did. I
She
pray
said she did?
Yeah, she said she did.
Okay.
So I hope she really did. She said she did.
Okay.
Thank you. State your name, sir.
London Battery.
Thank you.
Thank you, Judge. I have submitted a green sheet. We're requesting a 3 or 4th adjournment. We are undergoing mitigation, and I believe we're also investigating a potential motion.
How much time?
3 to 4 weeks, please.
Wow.
Whichever one is better for the court.
No. I see, I see how you snuck.
Not picking my date, just.
I know. I saw how you did that. May 20th,
Thank you, Judge.
2025. 9 a.m. bond will continue.
All right.
Oh, May 20th is 22nd.
The 22nd.
Yes.
Thank you, Judge.
Thank you, Miss. Court calls the case of the people versus Brian Gerard.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Gerard, Your Honor. He's approaching.
Your name, sir?
Brian Gerard.
Thank you. Okay, what are we doing?
Your Honor, I've had a chance to speak with the prosecutor and speak with Mr. Gerard. He'll be waiving his exam this morning. Oh, date, it's 24th. I have explained to him he has an absolute right to that exam. I believe the people have agreed not to habitualize this matter. 24th.
Sir, you're waiving your right to preliminary examination?
Oh, there you go.
Mr. Gerard, you're waiving your right to a preliminary examination?
Yeah.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes.
You understand that you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, Your Honor.
People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following.
Your Honor, we'd waive reading, stand mute, ask the court to enter a not guilty plea.
Defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea. Pretrial will be set for May 5th, 2025, 1:30, Judge Hammoud.
Your Honor, I believe he has other matters set with Judge Hammoud on the 12th. I don't know. Well, they'll just move him if he does. Thank you.
You're informing me of that because of why? You want me to give you the 12th?
I hate dead air.
What?
I hate dead air. No, the 5th is fine.
Okay, good. Thank you. Bond continued. Clear everything out. Court does call the case. People versus Gervais Drake.
Assistant Public Defender Jay Bellinger on behalf of Mr. Drake, who approaches, Your Honor.
Your name? Gervais Drake.
Your Honor, we're just asking to set for exam at this time.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available to 6.
We'll do our best, Your Honor.
Preliminary examination in person, May 6, 2025, 12 noon. That's before me.
Thank you, Your Honor.
Thank you. Bond continued. Court does call the case. People versus Haley Gregg. Oh, she was still here.
I'm back. Couldn't get rid of me that easy. Tino appearing on behalf of Haley Gregg.
Your name?
Haley Gregg.
This is the date and time set for PCC. I was just appointed quite literally about 10 minutes ago. So given that, I would be asking for an adjournment of the PCC.
The only thing holding her?
No, Your Honor.
All right.
Judge, it was my understanding that her only other hold was a Melvindale misdemeanor warrant, and Melvindale has indicated that they would not pick up.
You want 12 days out or you want 1 week? Because she's in custody. So I can do the 1st or the 6th.
Unfortunately, Judge, I'm in trial next Thursday, so I can't do next.
Can't do the 1st, so I'll set it for the 6th for BCC. It's a Tuesday.
I have a look at the 2,000 cash of surety bond on an RIO A and B case.
I thought you had you said you had
That's what he told me.
Yeah, the failure to appear.
All right, I'm just trying to give her the quickest date I can.
Understood, Judge.
So if you're not available the 1st, I'll do the 6th.
That would be great, Judge. Thank you.
May 6, 2025. That's at 9 a.m. All right, for a probable custody. All right.
Thank you, Judge.
Thank you.
Would also like to address bond. I know we've touched on it a bit. It's my understanding her bond in this matter is $5,000 with a 10% bond. It's my understanding of the circuit court matter that I think the people were mentioning a second ago. My client tells me she received a personal bond on that file at her last court date. She is 34 years old. She does have employment lined up should she be released. She would be working at a medicinal cannabis retail store. She would.
Okay. Now, go ahead.
She does.
Like she has a job at a liquor store. Go ahead. No, I'm kidding. Go ahead.
Very important jobs. It's a very important sector of our economy. She does have housing lined up as well.
Wow.
She would be
vouching for that.
She would be able to reside in the city of Ypsilanti with a friend. She also is on the housing list through Avalon Housing. She would be working with CMH. She, previous to her incarceration, was working with CMH and attended therapy at least 2 times a month. It's my understanding that the other holds out of Wayne, as mentioned, they would not pick up on. We did ask the court to consider a personal bond. If the court is willing to do so, we would also ask if the court would consider release to treatment. She has indicated that she does think treatment would be appropriate for her at this time.
Treatment.
Substance abuse treatment.
At the cannabis store. No, I'm kidding. Go ahead.
Your Honor, at this time, we believe that her bond is appropriate. She does have multiple other matters pending. We would point out that the date of abstention of this case is the day after she was released on another case. I don't know if you remember Ms. Gregg from last time she was here. But Your Honor, given that she picked up this case.
Because she had to get away from here after she was released. So she just grabbed a car. Whose car did she grab? Allegedly.
Allegedly, Judge.
Allegedly, it was a police car.
No, what?
Okay, never mind. My bad.
No.
And she's already had a failure to appear on the R&O case back in February. So we don't think that a reduction in bonds.
If I may, Judge.
Go ahead.
Judge, my only response to that would be treatment, I think, would be perhaps a great middle ground for her. She's indicated a willingness and a desire to obtain treatment. Certainly, I think with treatment there, the risk of failure to appear is significantly diminished.
If you prepare an order, I'll release her on a PR to treatment.
Thank you very much, Judge.
Your Honor, could there be a tether to keep her in inpatient treatment at that case?
Well, I'm not running.
I don't know that she's going to need a tether. I mean, if she goes into treatment, no, I'm not going to do a tether on her. I'll just indicate that she can be released from treatment on a PR.
Thank you, Judge.
At this point, however, her bond will continue.
Thank you.
Okay, so the People versus Muhammad Farr.
Ready, Judge.
Andrew Cho is agreeing on behalf of the people.
Court shall fix the first assistant public defender on behalf of Mr. Muhammad Farha. Please state your name for the record, sir.
Mohammed Farha.
Thank you, Judge. We are still in the process of trying to get this matter resolved. We are requesting a brief adjournment so he can provide proof of his treatment to the prosecutor's office, and we can hopefully find a resolution, Your Honor. He is in compliance, as far as I can tell now. Last time we were here, you had him go drop, and he dropped and came back.
I have proof of treatment with me right now.
Okay, well, he's going to need time to review it.
Okay.
So you're looking for how much time?
Just a couple weeks, Judge.